arraignment that was, I guess, on a probation violation that occurred on March the 12th. And I really wanted the 15th, 2012. They also gave me a copy of what is characterized as an arraignment tape where Your Honor called Mrs. Sproles up from the lockup, from the lockup where she was being booked to, and they call that arraignment. Okay, and at that point, what you were really doing is not arraigning Mrs. Sproles, but what you were doing.
Mr. Munson, no. You made requests for certain recordings.
Yes.
And I granted all of them. And those recordings, whatever you call them, the date that.
Yes.
So if you ask for a recording.
He did not
the
grant
you get that recording, no matter
the
how you
arraignment
characterize it,
tapes.
even if it was inaccurately characterized.
Because it was two. Because they brought me before the court two times.
A request for an arraignment by the judge on a date, but it wasn't the judge that did it. I still approve it as an attorney.
He was the judge.
Court, having signed that you promised that it would not be misused and not turned over and not put on the internet. The entire
See, this is when you know you're doing something corrupt. When you try to mandate a lawyer not putting a videotape or giving a videotape to the attorney Ferris.
I got the one for the 12th of March, but I did not get the one for October 15th, 2012. I did not get that arraignment tape.
I signed that approval on May 24.
You see how he arguing? This is a judge. He's arguing about something that's being requested.
What I got was the one that was marked arraignment, but it was the arraignment that you actually arraigned her on, I believe, at the time of sentencing. But that's not real clear either, because if you just read the sentencing transcripts, it doesn't really say what she was being charged with. Violation. It's a violation of some kind, but it doesn't say what the violation was. And Tishman goes into his thing about the opiates and being tested.
I asked about whether you had the arraignment recording of Magistrate Patterson on October 15, 2012, because this response you filed this morning makes an allegation about what is on it. But have you heard it yet?
I heard what, the arraignment tape?
Yeah, the October 15, 2012.
Arraignment tape. No, I don't have that one. I did ask.
No basis to make this allegation as to what's on it.
That
Actually,
is exactly what's on it. I was screaming and hollering from the basement of their jail. Let me, my civil rights is being violated. Can I speak to a lawyer, a manager, or a counselor? He's right.
It is really not an arraignment, but a reprimand by the court for her bad behavior and not wanting her fingerprints taken and arguing about her constitutional rights. And of course, she said court, but it was the magistrate that arraigned.
It was him. He is the one, the first administrator, Patterson James,
Why I asked if you already
had brung me in. He wouldn't take my complaints on the civil rights. And then when I came back from the basement of the jail, I came to him, which he said, "Oh, I'll put you in jail for 90 days. I don't care." But he's trying to hide that videotape.
I'm not saying that the magistrate reprimanded her. I'm saying that the court reprimanded her. It was about 2:38 in the afternoon when you called her up from downstairs because she was asking him, "Why are you fingerprinting me? Why are you fingerprinting me?" You called her upstairs and you admonished her about disrupting the court and disrupting your staff. That is what I have.
October 15 of 2012.
Absolutely, Your Honor. I have that tape.
Now watch you tell on
Look at
himself.
that tape. I do not have the recording that happened earlier in the morning where she was making all the fuss about her constitutional rights and what was she being booked for? Was she being arrested? That's the one that you said that you heard the ruckus downstairs and you heard her disrupting the court. That one I don't have. That's the one that you referred to when you called her upstairs and you talked about her bond conditions and whether or not you'd raise them, and you told her to be quiet, and eventually she did shut up and you let her go. That's the one we don't have.
All right. And you know how loud someone has to be for us to here in this courtroom, because that does happen from time to time.
You just told on yourself.
That somebody's so disruptive downstairs, it's right in the
I was yelling and screaming. My civil rights is being violated. I want to see a manager. I want to see an attorney. I want to see a counselor.
What happened with her on that day, and if I looked at that, it would refresh my recollection that that's one of those cases.
You probably remember that. I mean,
You'd be surprised,
Listen how he just told on himself, then back talked and said, "Oh no."
Because she was really cutting up. Because she did not know, in her mind, why she was being arrested. She did not know why they were taking her fingerprints, and all that stuff happened at that time.
Okay, so now
She
I
didn't-
understand the basis for that statement.
Right.
With regard to the reference by Mr. Teichman to the opiates, in fact, what her counsel was actually pointing out is that the Fulton County Pretrial Supervision Unit did report that a test of February 11, 2013 was positive for opiates.
Well, why can't I get the documentation?
He's right about that. And he was also
But you will
right
hear
to
the
correct
tape
record and say,
from
"That's because
Tishman.
he's got a prescription to write."
And you will hear nothing about that.
Whole issue.
They cut it out of the video.
Had he not done it, he could have been subject to being found in contempt for having taken
It was
opiates.
never reported from a
When she's not
doctor
supposed to be
that I
taking
was
opiates.
taking opiums.
And
Never. Never
Not
reported
a
from the
major
JAMS
agency where
center that I was
they always
taking
know that.
opium. This judge just committed a crime under oath as a judge.
and render it a non-issue.
What date was that, John, that she testified?
Well, this says it was a test date of February 11, 2013. The test result positive for opiates and Madison Heights jams received on February 18. And then, per James, defendant has a prescription on the file. He was making sure that that was not being used against her, which then clearly it wasn't.
Okay.
All right. So we come to the law cited by both parties on the underlying issue with regard to the request to set aside the plea of guilty. I have to say, first of all,
Now, the tape you just heard is the last time I was in front of this judge with an attorney. He threatened, you see, he's arguing my case. That is the judge. That is not the prosecutor. That's the judge arguing my case. So he lied, and if you listen to the tape, replay this back over, you will hear him say, well, that was a lot of records downstairs in the basement. And you know, for somebody to hear that, it had to be loud. Okay, so the only one would know that is the person who heard that. Right? Which was him. Then he comes back and says, well, I don't know who was it. I don't know the person or the judge who was on this case, but I will send everything that's necessary need to be sent. Listen to him.